Welcome to Fasken's 14th consecutive mining series. My name is Frank Mariage, and I'm part of the Fasken Global Mining Group, and I'm also a partner from Fasken's Montreal office. Today's webinar, the S in ESG, has landed on both feet in Canada, is the 7th in our series of 14 seminars this year. A calendar of all of Fasken's PDAC events can be found underneath the video window. Please refer to the slide on your screen for some webinar information. Now I will turn it over to my colleague, Brian Burkett, the moderator for today's session, and who will introduce the session today. Over to you, Brian.
Thank you, Frank, and welcome everyone. As Frank mentioned, my name is Brian Burkett. I'm a counsel in the Toronto office of Fasken, and I'm joined today by my Fasken colleague, Chris Pigott. Chris is a partner also from the Toronto office and practices in the labor, employment, and human rights group. Among his many specialties, it includes a full understanding of the business and human rights, the BHR concept that has taken hold of the international circles over the last decade. With those introductions done, let me turn to the next slide, Will, which lays out what Chris and I intend to do. We'd like to do an overview, really asking the question, where does this forced labor and child labor in supply chains act come from? The historical context, and then perhaps a quick catalog of Canadian advances in the social arena. B, we will delve into the legislation itself, kind of the guts of this session. I will do the key provisions. Chris is going to cover the compliance issues that have really bubbled to the surface as what would appear to be covered corporations are about to file their first annual report. And then finally, we'd like to talk about what's next. With respect to this legislation, but also with respect to perhaps a deeper piece of legislation, mandatory human rights due diligence, and then a question and answer period. So that's the session layout. Next slide, Will. So let me start with the historical context. And I think it's always helpful to kind of situate whatever you're dealing with in its historical context. So our current world economic system was actually created 75 years ago, coming out of the Second World War. And at that time, thought was given to ensuring that there was some kind of balance between, on the one hand, economic development, and on the other hand, social progress. Economic development became what we know as economic globalization. In terms of social progress, that's about the human condition within the world of work and workplaces, which is situated in the global economy, and it's dominated by multinational corporations, supply chains, trade liberalization, all these free trade deals, and technological innovation. There were three new international institutions that were considered to underpin the global economy. Two of them you've heard of, one maybe not so. The two you've heard of were the World Bank, which continues to be very active 75 years later, and the International Monetary Fund, the IMF. The third international institution was the International Trade Organization, the ITO. And the ITO, among other things, was intended to house the labor standards within economic globalization, the social side. But the ITO never came into existence. Its charter was not ratified by the US Congress towards the end of the 1940s. And as a consequence, and this is the key point, international business, multinational corporations, for the next 50 years or so, 1945 to about the year 2000, as they exploded on the international stage, were largely unregulated. It's interesting to note that in this period, the same 50-year period, one approach that emerged, which this audience will be familiar with, absent an ITO and labor standards, or any meaningful labor standards, was corporate social responsibility and codes of conduct, which are voluntary compliance by multinational corporations in their operations and activities, and sort of a commitment that a certain level on the social front will be maintained. However, around the turn of the century, just before actually, it was recognized in international circles that there was a social deficit embedded in economic globalization. In other words, there was a tangible, troublesome imbalance between economic development on the one hand and social progress on the other, if left unchecked, would threaten the sustainability of the global economic order. Efforts to repair this situation followed. I will quickly comment on a couple. In 1998, just before the turn of the century, and not that long ago, the International Labour Organization, the ILO, passed its Fundamental Declaration on Principles and Rights at Work, known as the Fundamental Declaration. And it included no child labor, no forced labor, and other provisions. But by the end of the first decade of the 21st century, there was insufficient progress in terms of repairing the social deficit. By the way, the numbers today would tell you, I'm now up to 2022, there'd be about 160 million child laborers in the global economy and 50 million forced laborers. A major source of the problem has been supply chains and the prevalence of forced labor and child labor within those supply chains. In 2011, so just over a decade ago, the United Nations passed the UN Guiding Principles on Business and Human Rights, which included a pillar featuring business's duty to respect human rights. This became what we now know as BHR, Business and Human Rights, also known as the S, the social, in ESG. The last decade or so 2011 to the present, has featured a number of initiatives to define and implement measures to regulate the human rights behavior of corporations. One particular initiative involves legislation at the national level, so within individual countries, to regulate the human rights footprint of business. Europe, the UK, and Commonwealth countries like Australia and Canada, the USA, these are the countries that are in the forefront of this legislative domestic initiative. These pieces of domestic legislation usually take one or more of three forms. The first is a reporting piece of legislation, which is about transparency or disclosure by corporations in terms of their human rights performance. The first example of this legislation, by the way, was the California Supply Chains Act from 2010, a pure reporting statute. The second of three types of this legislation involves something deeper. It's called due diligence legislation, and it really emerges from that pillar I identified in the UN guiding principles about businesses' duty to respect human rights, due diligence. Here, corporations are required to not just disclose their human rights performance, but rather demonstrate how they are preventing and repairing human rights deficiencies in their operations and activities. And prime examples here would be the German legislation from January of 2022, the Norway legislation, which is a piece of due diligence legislation, which came out in 2023. And Chris and I will talk a bit more about this later, the EU Corporate Sustainability Due Diligence Directive, which was tabled in Europe at the same time as the start of the Russian invasion of Ukraine in February of 2022. The third type of provisions that you find in this legislation relate to customs bans, importation bans. This legislation provides that importation of goods involving the use of forced labor or child labor is prohibited. And the United States is in the vanguard of this approach since its enactment of the Uyghurs Forced Labor Prevention Act late in 2021. So those are the three types of provisions that you find in this legislation. So it's in this context that Canada enacted in 2023, effective last month, so January 1, 2024, a fairly robust reporting statute, the Forced Labor and Child Labor in Supply Chains Act, which is the main topic of this session that Chris and I are presenting. So that's the history of how we got to this point. Towards the end of the program, we may talk about where are we going next. But first, we're going to delve into the legislation itself. And just before doing that, if you go back to this slide and take a look at it, just wanted to point out the Canadian catalog in the social arena as we speak to you today in 2024. So I suspect everyone in this audience is aware of the Canadian Ombudsperson for Responsible Enterprise, which came into existence around 2018. It now has a complaint procedure that's up and running. It concentrates on three parts of the economy: oil and gas, extractive, and garment, with a lot of activity focused on garment over the last 2 years. Then you have legislation, and this is the catalog of everything that's going on in this arena. Legislation, well, we have the reporting statute that we're going to talk about. There's also some talk about the deeper due diligence type of legislation. We will cover that later. Number 3, import bans. And you'll see there's an asterisk on your screen. There are only 3 countries in the world that have import bans. All 3 are signatories to CUSMA, which came into effect January 1, 2020. Those countries are, as you know, Canada, Mexico, and the United States. And the fourth thing about the Canadian catalog is it's about forced labor and child labor. And Canada is now the only country in the world dealing with both forced labor and child labor legislatively. So there's your catalog of what's happening in the social arena in Canada. I will tell you that it's kind of unfolded in a chaotic fashion. That may be because, unlike so many other jurisdictions, over 30 in number, all of this activity was preceded by what's known as a National Action Plan, an NAP. National action plans are really the blueprint of where that jurisdiction thinks it's headed in the social arena and what it intends to do and cover over the years ahead. Canada didn't do a national action plan, and it may have resulted in a somewhat chaotic approach to a very important social arena. All right, next slide. Thanks, Will. I'm going to go through the key provisions, and then Chris is going to really talk about what's kind of bubbled to the surface for corporations as they're really getting down to the task of trying to do their first report. And I guess it starts with, do they have to do one? So key provisions. And as we follow the screen, became law May 11, 2023, effective January 2024. The initial annual report has to be filed on or before May 31, 2024, by a covered corporation and every year thereafter. Next slide. So here's really the guts of the legislation. It's section 11.1, and I think it's worth going through it and unpacking it. So every entity must, it's required, on or before May 31 of each year, report to the minister, that's the Minister of Public Safety and Emergency Preparedness, on what? On the steps the entity has taken when? During its previous financial year to prevent and reduce, so to prevent and reduce the risk that forced labor or child labor, so both, is used at any step. And I want to pause there with the phrase at any step. That's referring to the supply chain. And as we know, supply chains involve cascading tiers. Tier 1 tends to have the contractual relationship between the multinational and the main supplier. But that main supplier will then subcontract. That's tier 2. And further on down the cascading supply chain to tier 3, to tier 4, and so on. Supply chains are very opaque and complicated. That phrase, at any step, doesn't refer to just tier 1, as, for example, is the main emphasis in the German legislation from 2022. It refers to every tier in the supply chain. Continuing on, what's it in respect of? It's in respect of the production of goods, that's number 1, in Canada or elsewhere, or of goods imported into Canada by the entity. So it's both about production of goods and importation of goods. So that's the real guts, I think, of the legislation. Next slide. 2 important points to note. Protected categories and covered corporations. Let's start with protected categories, and let's start with child labor. Next slide. So child labor means labor or services provided by parties under the age of 18. And this is not just an age determination. It's when you are of a certain age and the fact that you are working or providing services has some detrimental impact on that individual, that child laborer. What kind of detrimental impact? Well, to start with, it's maybe contrary to the laws applicable in Canada. You can't be working when you're 18. But here's the more significant one, or working under circumstances that are, quote, mentally, physically, socially, or morally dangerous. In every new piece of legislation, there tends to be the need for some judicial interpretation of new sections. I would have thought that this may be a section that will require some judicial intervention and interpretation for a complete understanding. But when you are, say, 16 years old, and the circumstances of your provision of labor or services is mentally, physically, socially, or morally dangerous, that runs afoul of this legislation. The third example, and these are just 3 highlights, there are others, is interferes with their schooling. So there's a quick preview of the definition of child labor that you find in the legislation. Next slide, Will. Forced labor. It means labor or services provided by a person that, quote, and here you're kind of looking at a, for those of us functioning in the labor and employment field, sort of like an occupational health and safety objective test, but could reasonably be expected to cause the person to believe. To believe what? That their safety or the safety of a person known to them would be threatened if they failed to provide or offered to provide the labor or service. That's the definition of forced labor. Next slide. So, the audience, the corporation, it asks, does the legislation apply to us? And the answer kind of goes like this. So, are you producing goods in Canada or elsewhere? You can see I'm back to section 11.1. Or are you importing goods produced outside Canada? So in terms of producing goods, there are a couple of sections in the statute that lend definition to that phrase, producing goods. Section 2 talks about manufacturing, growing, extracting, or processing of goods. Section 9, later in the legislation, adds selling, distributing. And at the very bottom there, in respect of not the production of goods issue, but rather importation, under the customs tariff provisions of the legislation, there's reference to goods mined, manufactured, or produced in whole or in part by forced labor or child labor. So, on that issue of importation, the Act extends the existing import ban under Canada's customs tariff to goods that are mined, manufactured, or produced in whole or in part by not just forced labor, which is the way it used to be written before this legislation, but also child labor. Next slide. Continuing with the question, are we covered and what do we have to do if we are? If in addition to those factors of producing goods or importing goods, you're listed on a stock exchange in Canada, or you have a place of business in Canada, you do business in Canada, or you have assets in Canada, and then there's a bit of a formula here about, and at least 2 of the following conditions apply in 1 or both of the previous 2 years. And now you see 1, 2, and 3. 20 million in assets, this is the threshold. 40 million in revenue, 250 or more employees. If all of that is happening and you're producing goods or importing goods, then you're covered. The point I'll make about this slide in 1, 2, and 3 is that's quite a low threshold. So in other words, the legislation is going to have pretty broad application, much broader than the similar kind of legislation that we see in the UK or France, for example. Next slide. sort of the last key area that I want to cover before passing it off to Chris. If you're a covered corporation, and we've kind of been through that, the annual report must include the following information in respect of the entity. Many of you will have reviewed all this. I think it's worth spending the moment to look at these 7 main provisions that become essential, I think, to what you're putting in the annual report if you are a covered corporation required to report. So the first is you're going to have to talk about your structure, activities, and supply chain. 2, policies and due diligence. And look, see that phrase, due diligence? That's from the UN Guiding Principles, the pillar that I mentioned earlier. That's what respect for human rights is. It's about due diligence. So your policies and due diligence processes concerning forced or child labor. Number 3, and this is almost a matter of self-declaration that will be read by many eyes, not just government, as you file the report with government, but it's the parts of your activities and supply chains that carry a risk of forced labor or child labor. So you're identifying this being used and the steps it has taken to assess and manage that risk. Almost a matter of self-declaration, I would have thought. Next slide, and number 4, any measures taken to remediate any forced or child labor. Related to that is the next one, any measures taken to remediate the loss of income to the most vulnerable families. Next, number 6, training provided to employees on forced or child labor. And finally, and 7th, and a lot like number 3, which I said is like self-declaration, it's number 7, how the entity assesses its effectiveness in ensuring that forced labor and child labor are not being used in its business and supply chains. That is really what's going to end up in the report that you may be required to file. Next slide. Just briefly, before turning this over. So what we also know from the legislation, these are key highlights, is the report must be signed and approved by a member of the governing body of the covered entity. So we're now involving the board of directors. Number 2, this one's critical. It's about the sunshine test. So the report has broad accessibility. It has to be filed with government. If you're a CBCA company, you have to provide a copy to each shareholder along with the annual financial statements. And finally, it has to be made available to the public through your website. So a lot of eyes will be looking at this report. It will be available. Shareholders, NGOs, trade unions, government, etc. 3 and 4, broad powers investigation are contained in the statute. And number 4, enforcement provisions. There is a penalty structure. 3 and 4 are about the movement, as described in legal circles, from soft law to hard law. Soft law involves voluntary measures by a corporation, like corporate social responsibility, an outgrowth of the first 50 years of the last century, but remains very active and effective today. Hard law, though, is about mandatory regulation of corporate human rights behavior, which would be, as an example, this statute. So on that note, with the background to the statute, let me turn this over to Chris to deal with the compliance issues that are really percolating today as we approach the deadline for filing. Chris?
Thanks very much, Brian. So as Brian mentioned, this legislation was introduced in Parliament some time ago, but it only became law. It was only enacted in mid-2023. It came into force on January 1st, 2024. And as Brian again mentioned, first annual report under the legislation is due no later than May 31, 2024. So the runways that we're talking about here for producing the report, which requires a lot of legwork, that runway is not long. And it's a particularly short runway given the fact that this legislation has really been the sleeper hit of the year, if you will. We still get emails from sophisticated companies, albeit the extractive sector has been very, I think, up to date on developments in this area, but certainly from other sectors, we continue to get emails and inquiries from clients who are just learning about this legislation as we sit here almost in March 2024, just a few months before this, the annual report must be published. So that's all to say that companies right now in Canada, multinationals with operations in Canada, are really scrambling to figure out what this legislation means. How do you comply in practice? Who's covered by the legislation? What does the report need to look like? These are all critical questions that companies are having to grapple with in a very practical way in light of their structure, their activities, and their operations, both in Canada and abroad. And the legislation, for those of you who read it, you will know this. The legislation is not long. It is not detailed. It is not the Securities Act. It is not accompanied by detailed regulations that set out exactly how a company should set out to consider whether it is covered by the legislation, and if it is, what it should include in the report. What we do have is a guidance document released by Public Safety Canada, the regulator in this case, in December, that provides some answers to questions that we have about how the Act applies. But that guidance document from Public Safety Canada also raises a lot of questions and leaves a lot of questions unanswered. And to me, I always get a bit nervous when a guidance document is released just over a week before the legislation that it discusses comes into force. And certainly what we've heard through informal discussions is that the government has been scrambling itself to figure out exactly how to deal with this legislation, given that it did originate as a private member's bill. This is not legislation that initially emanated from government. Lastly, the government itself has said that the guidance provided by Public Safety Canada may change. It may change as the legislation is implemented and as additional work in this area is done. So that's all to say. We still don't know a lot about how this legislation is intended to apply and how the regulator, how Public Safety Canada will interpret, implement, and enforce the legislation when that first batch of annual reports begins to hit later this spring. So what I wanted to do in the next little while is give you a bit of a snapshot, a taste of the types of compliance issues that we're seeing as companies prepare to publish their report later this spring. Now, this is just a snapshot. We've selected some of the key questions that we've been asked repeatedly. It is far from all of the questions that have been asked. Some of these questions don't apply to some companies. Some are more straightforward in some situations than others. But what I hope to do here is give you some sense of exactly how the legislation is unfolding in these early months. So first of all, one of the main questions that we've been dealing with at Faskens when talking to clients, including in the extractive sector, is who does this legislation apply to within our group of companies? Which entities are actually covered? So I don't need to tell this group that in the extractive industry, many companies have complicated corporate structures with a parent based maybe in Canada, maybe based outside of Canada. Many subsidiaries or affiliated companies in Canada, outside of company, joint ventures with other companies, Canadian and non-Canadian. Which of those entities does the legislation apply to? Now, in some cases, the answer to that question can be straightforward. For example, if you're a Canadian parent company listed on TSX or another Canadian exchange, you control some subsidiaries around the world, and those subsidiaries in turn have strong connections to Canada. And I'll tell you what I mean by that in a few moments. Perhaps they're importing goods back into Canada. The answer may be that everyone in the group of companies is covered by the legislation. But there are layers of complexity here. In that example, it could be that maybe some subsidiaries are covered, but some subsidiaries are not covered. For example, subsidiaries that have no connection whatsoever to Canada, but for the ownership relationship with the Canadian parent. It may be that that entity is not technically covered by the legislation, does not need to be the subject of its own annual report, other than perhaps to be mentioned as part of the parent's corporate structure in the parent company's report. So I've said that's a relatively straightforward situation, but it's still a bit complicated. Well, it can get even more complicated. Let me give you another example. This is actually an example that I've dealt with recently in the extractive sector. What if we have a non-Canadian parent company, not listed on a Canadian exchange, but it's got a significant Canadian operation? Is the foreign parent directly covered by the legislation? Is it required to do a report on its global operations, or is only the Canadian subsidiary, the Canadian operation, required to report? What about foreign subsidiaries of that parent with limited or no connections whatsoever to Canada? Do they need to be covered in a report? Do they need to file their own reports? All of these difficult questions need to be answered based on a close review of the corporate structure and, more importantly, the activities and of the various entities within the group and the links to Canada that may exist as between the parents, subsidiaries, non-Canadian and Canadian. It's a very complicated process that many companies are in the midst of right now in just thinking through the question of, does this act even apply to us? And who does it apply to? One thing we do know from the public safety guidance that was released in December is that even if you have a group of companies where some or all of them are covered by the legislation and need to report, what we do know is that Public Safety Canada is saying it's not necessarily the case that those companies should all be covered by a single report. And indeed, and I'll read you some of the guidance here to give you a flavor of Public Safety Canada's position in this area. And quote, a joint report should not be submitted in cases where entities within a group have risk profiles or policies or have taken actions that diverge significantly and in a way that would make it difficult to prepare a report accurately describing all entities. For example, a parent company that has implemented comprehensive forced labor and child labor policies that apply to its own operations, but not those of its subsidiaries, should not submit a joint report suggesting that its subsidiaries also have such policies in place. In cases where information applicable to each entity differs significantly, Each entity is encouraged to submit its own report. So even where you have a group of companies, in short, all covered by the legislation, it's not necessarily the case that they can or should submit a single report. A second related question that we're being asked a lot is how to deal with entities that have some connection to Canada or do some business in Canada, but it's very small. And this question has arisen particularly with respect to the interpretation of the entity test that Brian mentioned in his comments earlier, and specifically the requirement to be covered, an entity must have a place of business in Canada, do business in Canada, or have assets in Canada. The question we're being asked is, what does that mean? What does it mean to do business in Canada? Obviously, there's a broad spectrum of activities that most corporations engage in practice. And it's not always the case that it's easy to identify what doing business in Canada or having assets in Canada means. At least that's my perspective. According to Public Safety Canada, it should be a relatively clear-cut analysis. This is what Public Safety Canada has to say. It should already be clear whether an entity has a place of business in Canada, does business in Canada, or has assets in Canada. Entities should use the ordinary sense of these words and the criteria applied by the Canada Revenue Agency, given that no specific definitions are given or tests are prescribed in the legislation. Now, personally, I get quite nervous when any regulator says, it's really obvious, just go talk to the CRA about how these words should apply. It's much more complicated, in my view, in practice to figure out what the legislation means when it says something like, you do business in Canada, you're covered. What does doing business in Canada mean? Well, to date, and this is based in part on the guidance, it appears that the analysis needs to focus, the doing business in Canada analysis really needs to focus at a granular level on the types of activities that a company engages in within Canada. So, for example, is the company producing goods in Canada? Is it selling or distributing goods in Canada? Does it have any employees located in Canada? Does it have any bank accounts in Canada? Does it file taxes in Canada? Does it take any deliveries in Canada? Does it make purchases in Canada? Does it make payments or contracts in Canada? Does it even have any assets or inventories in Canada? These are all the types of questions that we are asking when we work with our clients to try to determine whether an entity is, in fact, doing business in Canada. It's also not always easy to determine whether a company has assets in Canada within the meaning of the Act. And again, assets in Canada is another one of the threshold tests for the application of the Act. Sometimes it's obviously going to be quite clear. A company has land, if it owns buildings, owns capital equipment that's in Canada, yes, those are probably assets. But the public safety guidance also talks about the fact that intangibles, such as goodwill, can constitute assets within the meaning of the Act. So even with respect to having assets in that analysis, there is some ambiguity in which companies, which types of operations are going to be covered and which are not. Now, as we've been working through this with clients, what we've developed is a bit of a framework for thinking through these assets. And all I will say is that we don't necessarily think it's the case that having a mailbox in Canada is going to loop a company and loop an entity into the Act. And that's for a number of reasons. And without getting into the legal analysis here, we are reminding ourselves that this is a piece of Canadian legislation. And there is a presumption that Canadian legislation is not, in most cases, intended to apply extraterritorially. And so if you have an entity that has a very limited or no connection to Canada, it's not necessarily the case that it's going to be swept into this legislation. But of course, this requires a very detailed, contextual and fact-based analysis that's going to diverge case to case. And that's what we're seeing a lot of our clients have to work through right now. Another question we're being asked quite a bit is, how far down the supply chain do you need to go when you're thinking about the contents of the report? And in some ways, this is a more straightforward question than the questions I've just been asking about how do you decide if you are covered. Because the short answer, according to the guides that we have, when interpreting how far down the supply chain do you need to go, the short answer is you need to go far. The expectation on a plain reading of the legislation, the expectation that's quite clear, I think, on the face of the Public Safety Canada guidance, is that that you should be reporting on your entire supply chain, right down to the last tier of your suppliers. So right down to the level of raw materials and how they're being supplied, how they're being fed into the supply chain at the end of the supply chain. And that's with respect to both direct and indirect suppliers or contractors, both in Canada and outside Canada. So we're talking about not only subsidiaries, we're talking about third-party contractors and suppliers to subsidiaries. Those need to be covered off in the report. And Brian, as Brian mentioned, in the contents of the report, when you're describing the structure and nature of the supply chain that is in play in your business. At the same time, I think that there has to be a recognition that, especially in these early days of the legislation, that it's simply not going to be possible for all companies to provide that level of detail, extending down to the very end of their supply chain, because in some cases, companies just don't know at this point in time all of the suppliers that they or subsidiaries or suppliers may be dealing with. It's very hard to know this without extremely rigorous monitoring processes in place. And there does appear to be a recognition in the guidance that the description should provide as much information as possible. It uses words like "to the greatest extent possible." The source countries, the end supplier should be mentioned. And so I think that in practice, while it's quite clear that the legislation is intended to extend all the way down the supply chain, it's going to be very interesting to see how in practice that requirement is enforced. One related question, just before we move on, one related question that many companies are grappling with right now is, we've tried to do in the past a good job of knowing what our supply chain looks like. But what sort of formal processes can we or should we put in place to make sure that we're getting the best picture possible of what that supply chain looks like? And what we're seeing is a lot of companies, and some have been triggered to do this by the introduction of this legislation, some companies are beginning to implement more formal investigation processes, often through their procurement people, often through their operations teams, that establish investigation procedures and monitoring systems that allow them to get the full scope of their supply chain. Others are requiring either new or much more robust attestations from suppliers, confirming that the supplier, the contractor, has taken steps to ensure that there's no child or forced labor in their operation or supply chain. And again, to require some sort of certification alongside an attestation. Those are some of the steps that we're seeing some companies take at this point in time, if they haven't taken those steps already. Next slide, please. Another question that we're being asked is around what the legislation requires beyond the annual report that Brian described in his remarks. Does a company need to introduce new policies, new due diligence processes, or training for employees as a result of the legislation? Do we need to take any other action? And the short answer is no, with very minor exceptions. This is a piece of reporting legislation. It imposes an obligation on covered entities to report on what they are already doing in the area of human rights, in the area of forced labor and child labor. It does not require new steps to be taken in this regard, at least strictly speaking. So again, there is an obligation to report on any training you provide to employees with respect to forced and child labor. That is an obligation to report on what you're already doing in this area. It does not require you, legally at least, to introduce new training. But of course, what's the practical consequence of this new reporting obligation? Well, we're seeing many companies who, for example, don't have training for employees in this area begin to introduce, or at least explore the introduction of new training programs, new due diligence policies and processes, new policies on forced and child labor that they may bring into effect or have already brought into effect in response to this legislation. And that's for a couple of reasons. And I bucket those reasons into two broad categories. First of all, there is a serious element of reputational risk in this legislation. Again, these annual reports are not only submitted to government, they need to be published publicly. They need to be made available on the company website. They need to be provided to shareholders if you're a CBCA company. So obviously, many companies are of the view that we want to be able to demonstrate to the world that we're doing a good job of ensuring that there are no or limited human rights risks in our supply chain. So as opposed to reporting that you do nothing in the area of training for employees, many companies who haven't to date done training want to be able to say, this is what we are going to do next. These are the policies and processes that we're introducing. The second reason why I think some companies are taking steps to bring new policies and processes into place is a concern about litigation and legal risk. Obviously, we're in quite a fast changing world right now in the area of forced labor and child labor, and I think that many companies are concerned about being at odds with best practices. They're concerned about appearing to be negligent, either from a public perspective or legally negligent, in respect of what they're actually doing in their company to address forced and child labor. Now, obviously, and just to really emphasize, there's no legal liability in these areas that's created by this legislation directly. I think a lot of far-sighted companies are beginning to think about what the litigation and legal risks could be down the road as a result of legislation like this. Another question that we're being asked is, how much detail should be included in the report? Do we need to write a book about what our operation looks like? Again, first area of supplementary information that the legislation requires us to report on is the corporate structure, supply chain, and activities. Well, a lot of big companies, a lot of sophisticated companies with global operations could write a small book on what their structure, activities, and supply chain look like. How much detail actually needs to be provided? Well, the short answer is that there's no prescribed level of detail that needs to be provided, and Public Safety Canada and its guidance has been quite clear in this area. It's also said very clearly that it thinks annual reports should be 10 pages max in length. So there is at least a soft page limit of 10 pages on the annual report. And I take that as a strong signal that the level of detail that is to be provided in annual reports is not shallow, but it's not necessarily extensive. You don't need to provide a very detailed report of all of your activities and all of your corporate structure to a deeply granular level. You certainly need to cover those topics, but you may be able to do so at a 10,000, 20,000, 30,000 foot level. Again, in light of the fact that we're talking about a 10-page limit. And one thing that we have been recommending our clients to do is to take a look at the public reports that have been made by companies who are covered by the existing modern slavery legislation in the UK or in Australia. Those governments operate publicly accessible websites where companies for some time have been required to post their report, and they will give you a sense of the level of detail that is required. And again, it's usually comprehensive in the sense that a broad range of areas and activities are covered, but they do not get into an incredibly granular level about those activities and subjects. What are the consequences of non-compliance with the legislation? And we've just actually had a question come through the Q&A about enforcement and how the legislation is going to be enforced. So what are the consequences of non-compliance? Well, the legislation is enforced by government. And again, Public Safety Canada is effectively the regulator in charge of monitoring compliance with this legislation. There are really two enforcement mechanisms under the legislation. First of all, and this is on the what I'll call the upfront enforcement side, Public Safety Canada or its delegates have quite a broad ability to search and inspect corporate premises, corporate databases, etc., to determine whether or not a company has complied with its reporting obligation under the Act. So are there intentional inaccuracies in a report, all of that sort of thing. There is a power for the government to do basically search and seizure type processes to enforce compliance on that. Second, there are consequences of non-compliance spelled out in the Act. So there are consequences for failing to file an annual report and other areas of non-compliance around that reporting requirement. And those include director and officer liability. Directors and officers can be held liable on summary conviction for a failure to file the annual report if they need to. And the legislation prescribes fines of up to $250,000. So there are quite serious consequences for non-compliance with the legislation. But at the same time, that's what the legislation says. The question is, what's Public Safety Canada? What's the government going to do in practice? And to date, Public Safety Canada has said that in this first year, in these early years of implementation, the government is not going to be focused on hard compliance measures, such as fines, such as searching, exercising its full scope of enforcement powers to ensure that companies have complied, or to sanction non-compliance. Instead, Public Safety Canada said that it's going to take more of what we call an educational approach to compliance. It's going to educate companies about what they should be doing with respect to determining who is covered by the legislation and with respect to the content for filing the content of the annual report. So again, no focus on hard compliance measures at this point in time. It's going to be an education approach. And I think that's welcome news for all, in light of the fact that, as I've alluded to throughout my comments, this legislation is, to a large degree, vague in many areas. Public Safety Canada guidance answers some questions, but not all, and it raises some questions. So I think it's a good thing for all and quite appropriate for the regulator to be thinking about how to educate companies on what I think it's fair to say is going to be a developing piece of legislation. On this, I think it's very important to emphasize that, as Brian mentioned, there will be thousands, if not tens of thousands, potentially more, companies that are, for the first time, going to be covered by legislation like this. The financial criteria, the threshold tests for the application of this legislation are very low. So, in some ways, if you're not a mom and pop convenience store, you may be covered by this legislation. And from an enforcement perspective, that obviously is a huge load for the government to handle for the first time. It's simply not the case that the government out of the gate is going to have the resources to properly enforce and implement this legislation across the whole range of companies that are now covered. Some companies, as I mentioned in my introduction, are just learning that this legislation exists. So I have to imagine that there will be many examples of complete non-compliance, a failure to file any report at all in this first year. So everyone, companies and the government, are going to need to get up to speed for a period of time, certainly in this first year and probably for years to come. Next slide, Will. Okay, very briefly, what's next here? Well, we're in quite an interesting period, to say the least. We have, when it comes to human rights reporting, when it comes to forced labor and child labor and supply chains, in a period of really decades where any sorts of human rights monitoring, for the most part, has been done on a voluntary basis by companies. We've had CSR initiatives. We've had companies entering voluntarily into agreements with stakeholder groups, rights groups, governments with respect to human rights. But we haven't, in Canada at least, had hard legal obligations, certainly in the form of legislation. But then, relatively recently, we've seen some legal action in the courts with respect to alleged human rights abuses abroad. And then now, in Bill S-211, we have, for the first time, legislation imposing some obligations, reporting obligations on companies. Now we appear to be moving quickly. This legislation comes into force, focused on disclosure. But now, and as Brian's going to speak about in just a moment, now we have on the horizon additional corporate obligations in the form of requirements to take proactive action to address, to identify, address, and correct human rights abuses in supply chain in the form of things like mandatory human rights due diligence legislation. So in short, we're moving rapidly from a period where talking about reporting or disclosure obligations to actual legal obligations for companies to do something in the area of human rights in the supply chain. And Brian, I think I'll toss it over to you to make some additional comments on this area.
Thanks a lot, Chris. Let me go to the next slide, Will. So at the same time as the act that we've been dealing with was coming into existence, we had the March 2023 debates in the House around the budget. And at that time, the Deputy Prime Minister, Chrystia Freeland, she indicated that the government would be coming out with mandatory human rights due diligence, quote, by 2024, unquote. One of the reasons that she was saying this is because of the origins of Bill S-211. It was as I mentioned earlier, a private member's bill out of the Senate. It was not authored by the government. And so they never fully took ownership of it. However, there was such support for it in the country, as reflected in the House, and it became law, that we had the new piece of legislation. So what the Deputy Prime Minister was saying is the government was going to really step in and maybe go a little deeper. And they were facing some opposition to the fact that Bill S-211 was simply a reporting statute, heavy duty as it may be, but still a reporting statute, not a due diligence piece of legislation. So the government, has been moving towards, I think, crafting another bill. There was a consultation up in Ottawa on October 13, 2023. Things have been fairly quiet since then on this next piece of legislation front. I would have thought that the Canadian government, if indeed it is headed in this direction, and it will bring to fruition the comments made by the Deputy Prime Minister in the budget debates last March, that they will look to Europe, which is really in the forefront of this type of legislation. Germany passed a mandatory human rights due diligence act effective January 1, 2023. Norway has the most recent mandatory human rights due diligence legislation. And what has been floating around over the last 2 years is an EU directive on corporate sustainability, a due diligence directive. So that is percolating in Canada. But since the Deputy Prime Minister made her comments, I think there's two significant developments that may have an impact on what happens in the future. The first is internal, like domestic, but the other is external, and it relates to Europe. The internal one is this. I think when Deputy Prime Minister Chrysler Freeland spoke in March of 2023, the legislation hadn't been enacted, and we certainly didn't have guidelines, the questionnaire, the attestation. The Ministry of Public Safety and Emergency Preparedness has made the legislation quite robust in a way that may not have been envisaged even by the government in respect to this piece of legislation that they did not author in March of 2023. That may cause them to pause late in the current mandate of this government, with the next election coming in 2025 at the latest, about layering on yet another layer of legislation in what we've described under the social agenda is a fairly chaotic set of circumstances. That's the internal factor. Externally, Europe, as of yesterday, February 28, the EU failed to pass, by way of a vote in the EU Council, the EU Corporate Sustainability Due Diligence Directive. The problem that arose over the last few months is that some of the leading countries in the EU, especially Germany, were concerned about this legislation for whatever reasons, economic, political, and otherwise. And so Germany had indicated that they would be abstaining from the vote in the EU Council. France, Italy, other countries also had concerns about the legislation. So it did not pass as of yesterday. And I would have thought, and Chris can correct me if I've got this wrong, I think it means it's pretty much off the rails, given that there will soon be another set of elections in the EU. And it would only be after that set of elections that all of this may be revived or not. So there are two recent developments that may have an impact on the government's stated intention from last March 2023 to implement yet another deeper piece of legislation that we would call mandatory human rights due diligence. Chris?
Thanks very much, Brian. And I don't have anything to add on that. So I think happy to open it up to questions unless, Brian, you have any closing comments to close off the content.
No, I'd be happy to listen to field any questions. By the way, Chris, there is one more question in the Q&A about software as service, I think, companies, and whether or not it would be covered. Do you want to field that one, or?
I'm happy to answer that one. And the short answer is a software as a service company could possibly be covered by this legislation. Again, the legislation is very broad, and in addition to the financial thresholds that Brian discussed earlier on, ultimately the analysis looks at whether you're producing, selling, or distributing goods in Canada or elsewhere, or whether you're importing goods from outside of Canada into the country. And one thing that we've discovered while working with clients is that even companies that, say, for example, are mainly engaged in providing or selling services to the public can be captured because, for example, they happen to import a lot of information technology equipment from outside of Canada into Canada. There's nothing that says that this legislation only applies to products or goods that are being passed on to or sold to a customer. Goods that are being produced or imported, even for internal corporate use, can certainly cause a company to fall into this to this area, so, or to be covered by the Act. So again, that's a long way of saying yes, it's possible that a software as a service company could be captured.
Thanks, Chris. Any other questions that you may want to deposit in the Q&A or that we could field? We do exist. We are around. If you're not thinking of any questions at the moment, we are around subsequently to field and try and answer your questions. But let's just pause for a moment. So there is a question that's just gone into the Q&A. I'll leave it to you, Chris. Is there any indication that the Ministry of Public Safety will coordinate with the Corps on potential investigations or follow-up based on the reporting results?
It's a very good question. And there's no specific indication that public safety is going to coordinate with CORE in this area. But I think that we should assume that there may be some coordination there. I think what we do know, though, and this is probably more concerning, certainly more impactful, is that we do know that Public Safety Canada may coordinate with the customs enforcement regulator with respect to considering import bans or certainly inspections if there is reason to believe that a particular company is importing goods that may have been produced by forced or child labor. Public Safety Canada has indicated that there may be cooperation with Customs and Border Services. So that's something I would keep your eye on. It's a long way of saying, really, that these reports are not simply going to be submitted into the ether. It is possible that further action could be taken by government with respect to the contents of the reports. And there's one other question about the recent slides use of the word "we may be moving into a new world of hard disclosure," and whether or not that suggests that this may all be short-lived. And I think, as Brian's just explained, the movement towards harder legal obligations in this area certainly is facing some headwinds. There certainly are opponents of the steps that are being taken in this direction. I think most people on this panel have probably at least heard of the types of opposition that the ESG movement is facing in the investor community, particularly in the United States, but not limited to the United States. And even outside of the investor community, certainly I think governments are concerned. There, as Brian described yesterday, at the EU level, certain governments opposed the adoption of the EU's proposed corporate sustainability directive because they were concerned that it was moving too far towards legal obligations that would be very difficult to comply with. So I think what I would say on this, and Brian, I'd invite you to chime in, what I would say is that we're just not sure yet how far and how quickly the move in this direction will go. What I do think is certain is that we're going to continue to see movement in this area. It's probably going to be uneven, may not happen at the international level or the regional level in the EU, for example, but certainly it does appear that in Canada, we're marching towards harder legal obligations that will apply in the future. Brian?
I have nothing to add to that, Chris, other than to say that if we relate it specifically to Canada, I think the point we're making is the government has a stated intention, and that's to move to mandatory human rights due diligence. That would be the shift to real action. But there may be circumstances that are arising, very recent circumstances, the headwinds that we're referring to, that may cause the government to reflect on whether that's the right thing and the right time to be doing that. That's the point that we're making and why we reference may be moving.
Mm-hmm. And just another new question's just popped up. Do you think that companies would cut connections with Canada to avoid being subject to this legislation? Would this have an economic impact on Canada? Well, to answer the second question first, I think certainly if companies begin cutting their ties with Canada or limiting the business they do in Canada, that would certainly have an economic impact on the country. I think that the key question at this point in time is, are companies going to make meaningful changes to any business they do with Canada, any connections that they have in response to this legislation? And what I can tell you is that based on the discussions we've been having with our clients across a range of industries, is that I certainly haven't heard of any company that's going to make meaningful changes to its corporate structure or meaningful changes to its business activities in response to this legislation. Now, that may be because we're so early in the game when it comes to the implementation of the legislation that we don't quite know what the actual concrete impact of the legislation will be on companies. So I think that's a question where we'll just need to stay tuned and see how things unfold in coming months and years. Okay.
I think on that note, Chris, maybe we should be thanking the audience for attending, joining us today. Chris and I and Fasken, I hope you have found our session timely and informative. Our next PDA session will be taking place on Monday, March 1 at March 4 at 7:30 a.m. Eastern Time on the topic of a challenge for the nascent nuclear energy renaissance, harnessing the dynamics at play in the uranium mining and fuel supply and enrichment sector. You can sign up for any of our upcoming webinars through the virtual calendar below or by visiting the Fasken Institute section of fasken.com. We hope you have enjoyed this session. We thank you for attending and participating. Have a good rest of the day.